Okay, and it started. Okay, so I'm just saying a few words. Thank you, everybody, every one of you for being here today, the speakers and the students, graduated students and PhD students in the University of Palermo and abroad. This can be seen as the, a final conference, a final meeting of a project funded by the Ministry of the University and Research and the European Union through the Next Generation EU program that has been funded in 2022, and it's planned to end in February 2026, which is dedicated to the topic of hybrid threats and democratic resilience. The name, you could find the entire name on the bag that is on your chairs. Hybrid threats versus democratic resilience, an analytical and practical toolkit. And we are very proud of the results that we are reaching right now. This is a project that involves also other units, a research unit at the University of Teramo and a research unit at the University of Cagliari. So I also say hello to our dear colleagues in the other university. So this is, in a way, this is the final event of the Palermitan track of this project, and we decided to focus on this specific topic of instrumentalization, or even worse, weaponization of migration in recent times. But I also need to thank my dear colleagues, and Lorenzo and Francesco decided to co-host this seminar today. In particular, Francesco, he will be saying something about that later on. He is the principal investigator of another project, Reconstitution. So this is really a multifarious and multi-layered conference today. And I also need to mention Massimo Starita and Enzo Tramontana is there. These are the members of the Palermitan unit of this research, of this ministry-funded research. So I will just take some few words to introduce you to the topic of today, hybrid threats, which is the topic, the subject of this project. And when we come up with the acronym, I think that most of you are familiar with European projects. So you're requested to identify a title and then an acronym. Without an acronym, apparently you can go anywhere. And we came up with this idea of Hydra. For those of you who are familiar with the Greek mythology, Hydra is the monster serpent, like three-headed monsters that Hercules fought back in the days. And the main characteristic of the Hydra is that it has three heads, and once you chop one head off, suddenly two heads appear. So in a way, it's a monster which is impossible to defeat. Even the last head that is there provides the Hydra with immortality. So it was just up to Hercules to defeat and to fight the immortality of the beast. And the sensation that we had back then when we decided to dedicate 2 years of our expertise to this topic is that it's a phenomenon that it's quite hard to catch. Like the heads of the Hydra that are always popping up and are never stopping to appear. Once we solved one particular problem about hybrid threats, suddenly three of them appeared back then. So how can we make sense of the complexity of this reality? Keeping in mind that the term hybrid threat was crafted by the European Union and by NATO some 15, maybe 12 years ago, and apparently it describes everything that is done against a particular number of states. So the difficulty to grasp the concept of hybrid threat from a legal standpoint. We are interested in legal definition, legal categories, and possibly even the legal regulation of this phenomenon. And what we decided to do is to adopt a clustered approach to hybrid threats. It was kind of impossible to bring everything together and treat all hybrid threats as a whole. We really needed to identify some domains, some fields in which legal analysis could be conducted. So we identified the domain of the information realm. So all the practice regarding misinformation, disinformation, in particularly keeping in mind electoral interference, which is something that is quite topical even today. If you're familiar with the US case, or even more recently, the Romanian case, the Constitutional Court of Romania that quashed all of the elections in 2024. So this was the first cluster. The second cluster being critical infrastructure, and I think that most of you are familiar with the sabotage, these acts that occurred in the Baltic Sea, the Nord Stream pipelines. So this is something that we hear in the newspapers very frequently. And then, last but not least, the migration domain. So the idea of using migrants, using people as a weapon between states, which is quite new, I think, but there will be a lot of critical approaches to that later on. So my suggestion for you today is that we are focusing on a specific topic, the topic of migrants, and I urge you to keep in mind at least 3 questions that may help you throughout this journey. The first one is, who is the source of hybrid threats? According to the documents that will be quoted, that will be discussed today, where do they come from? And you will discover pretty soon, I don't want to make any spoiler to you, but you will expect pretty soon that the actors are named and shamed in many documents. So we are referring to Russia, most of the times China, non-state actors, sometimes Iran or North Korea. But it seems like the list of the sources of threat is pretty much identified. So first one, who is the source? Second one, who is the target? And then you'll discover that in most of the documents, targets are presumed to be some states, in particular in Western states in the Euro-Atlantic areas. Those are the states that have some inherent vulnerabilities. Forgive me if I say this expression, but these vulnerabilities lie in the respect of human rights. In there being democratic states in which reactions to hybrid threat may be constrained by some legal requirements, both by constitutional and domestic law in general, and by international human rights, European Union law. So who is the target? Who is the source? Who is the target? And what is the purpose of hybrid threats? The overarching purpose of hybrid threats is to say it as frankly as I can, is to destabilize the other. So these are a malicious activity aimed at creating some chaos in those democracies. So the idea of destabilization goes hand in hand with another idea of a permanent confrontation between states. States are permanently confronting themselves, even in today's multipolar world, as some experts say. The idea of confrontation is that even if it's not a full-scale conflict, even if it's not open hostilities, there still is some confrontation. So states want to gain advantage over the other. And I cannot but show you a document that I came across this week, and I will translate that for our non-Italian friends. This is a paper, at least is a non-paper, it's been written here, but irrespective of our discussion about the legal relevance of non-papers compared to papers, this is a paper submitted by our Ministry of Defense before the Supreme Council of Defense. I don't know if this is the correct expression in English, is a constitutional body set forth in the Italian Constitution, which is chaired actually by the President of the Republic, and has also featured the presence of the Prime Minister and other ministers, such as the Minister of Defense. So right now, the President of the Republic has scheduled a meeting of the Supreme Council of Defense dedicated to the reality of hybrid threats. This is in November 2025. We may say a little bit late, seeing what's going on in the world, but still, this is something which is really momentous in Italy. So maybe today will help to shed some light on a topic which is very, very, very discussed and very, very heated in the debates in Italy. So even Italy is now discovering for the first time the idea of hybrid threats, and is pretty much focusing on that. So without further ado, I'm done. I've spoken even more than I expected, so I apologize to all of you. But I think that right now it's time to welcome on board the first speaker of today, who is Francesca Tammone, and I'll give her the floor pretty soon. Just a few words of presentation. Francesca Tammone right now is assistant professor of international law at the University of Magna Grecia of Catanzaro in Calabria, and she was a PhD student at the PhD program of Human Rights, Evolution, Protection, and Limits. I forgot. Sorry, Francesca, for saying that, but I forgot to mention among the source also the PhD program that, curiously enough, was the PhD program that brought Francesca here today, myself, and even Lorenzo. So it's a way of also to say thanks to this program that made it possible for us even to build a friendship out of that. And Francesca attended a PhD course in human rights here in Palermo, then was postdoc researcher in international law at University of Florence, and right now on this position at University of Magna Grecia. So Francesca will present on the topic, can the instrumentalization of migrants fit in the concept of hybrid threats? So pretty much a general introduction is the way to enter the topic of today's session. So I thank again Francesca, and the floor is yours, 25-30 minutes, and for you.
Good morning to everyone, and thank you very much, Diego, and thanks to all the organizers for having me and for putting together such a timely conference. This is timely because both hybrid threats and instrumentalization of migration are becoming recurring tools in international and European legal discourse, and I can truly appreciate the evolution in this field because the first time I heard a speech about the interrelation between these two concepts was here at the University of Palermo, when Professor Sarita organized a conference in the aftermath of the crisis at the Belarus border. And it was the beginning of 2022. Now, more than 3 years later, I can see the major developments occurred in this field. As you all know, other migration-related episodes have been framed as hybrid threats. But at the same time, the instrumentalization of migration has actually shaped the lawmaking, because now we have a proper legal definition of instrumentalization of migrants, which is that provided by Article 1, Paragraph 4, letter B of the 2024 Regulation of Crisis and Force Majeure. So we will witness in the near future the tangible effects of the adoption of this definition, and as well in 2026, this regulation will start to apply together with the fact of migration and asylum and the amended version of the Schengen Border Code, which includes the definition of instrumentalization of migration. And these key developments are also accompanied by the expected judgments from the European Court of Human Rights and other further developments in the application before the International Court of Justice in the important case Lithuania versus Belarus. This brief chronicle already reveals how complex and delicate this field has become, especially in terms of fundamental rights protection and interstate relationships. So I'm very much looking forward to hearing today's speakers and listening for the incredible insights on navigating these imminent challenges. But however, my task today is different. I just take a step back and try to answer a preliminary and foundational question, which is also the title of my speech. Can the instrumentalization of migrants fit in the concept of hybrid threats? The answer is not as straightforward as it might seem, or better say, should not be so. The first difficulty is that on the one side, we have now a legal definition of instrumentalization of migrants, which I mentioned before. But on the other side, we don't have, and Diego already anticipated me from this point of view, we don't have a legal definition of hybrid threat, which is used interchangeably with the terms hybrid attack or hybrid war, depending on the context. So let me start by outlining what is meant by hybrid threats. As already Diego said, this concept originated in the military sphere, where it described a combination of regular and irregular tactics in a single theater, but it has gradually evolved into a broad umbrella term for an increasingly broad spectrum of hostile activities. They could be violent and non-violent and across civilian and military domains, to cite the words of the European Center of Excellence for Countering Hybrid Threats. This evolution can easily be explained with the growing necessity to describe the contemporary way of conducting hostilities in international law, which is becoming more and more sophisticated due to the technological advance. These progresses have made it possible to use non-traditional weapons to fight without using traditional arms. So NATO had the necessity to describe the new way of conducting hostilities with a word that could encompass all the activities that cannot be compared to properly war, but are below the threshold of warfare because of their low intensity. So this term, hybrid threats, now covers many phenomena, very different in nature and scale: cyber attacks, electoral interference, and disinformation campaigns, and most recently, hostile activities in the outer space. As Diego said, this concept is mainly used in NATO tools, and these NATO tools are also upheld by European Union. And NATO described many policy documents that reconstruct the main feature of hybrid threats as coordinated and synchronized actions that deliberately target the systemic vulnerabilities of democratic states to reach strategic goals and create the desired effects. Such qualification is so broad that it's difficult to exclude something by this definition, also because in other policy documents, NATO also clarifies that these actions may be carried out by both state and non-state actors, and it can be posed by conventional and non-conventional means as well. In the words of Susanna Sanz-Caballero, this makes some side effects because hybrid threats create a gray zone that is neither nor war nor peace, and they exist by their very nature in the realm of legal uncertainty. I can argue then that this concept may be politically powerful, but legally elusive, and this is this ambiguity that we must confront when assessing whether migrant instrumentalization fits or can be made to fit this paradigm. As you may know, institutions of the European Union and some member states, and also some scholars, describe some episodes related to migration as hybrid threats. As Diego mentioned before, we must identify the specificities of instrumentalization of migration and the implication of using hybrid attack in this specific context, because the term applies to different situations, but I think that instrumentalization of migration has specific features and implications we must pay attention to. The first episode in which the hybrid attack narrative was used was in 2020, where the EU-Turkey agreement was suspended. And this resulted in violent pushbacks at the Greek border by Greek authorities. After some months, an increasing and sudden rise of arrival of 2,000 migrants tried to cross the fence in Ceuta to arrive in Spain, and this was considered a reaction to put political pressure on Spain after a diplomatic dispute. The microphone on someone is open. And so also this episode was considered the result of political tension between these two states. More recently, we also had sudden rise of arrivals at the Finnish border that also provoked a violent reaction by Finnish that also adopted restrictive migration policies. But of course, the case that perhaps best illustrates the violent dynamics and the distortive effects of migrant instrumentalization maybe remains the case of Belarus, which started in 2021, but the consequences of this tension between Belarus and the neighboring states, Poland, Latvia, and Lithuania, are still ongoing. And as you all know, the Lukashenko's regime facilitated the arrival of hundreds, thousands of citizens at the border of the states by also facilitating the transport, but also issuing the visas for them. All these episodes can be targeted as hybrid attacks, can be described as hybrid attacks. Because if we come back to the definition of NATO, we can see all the features that are provided by the qualification. They are coordinated actions that involve different actors and have a political purpose, exploiting vulnerability. In this case, the vulnerability is the adherence to human rights treaty and to refugee law that make European states more vulnerable to this kind of actions and operation. So yes, these episodes can be described as hybrid threats. It's difficult to refute this position because of the breadth of this concept, which is not legal. But it was really necessary to qualify these episodes, these events as hybrid attack. Was also possible to adopt other conceptual tools. I think that other conceptual tools existing in international law were also relevant. This is the position of the part of the scholarship. And I think this is an overlooked narrative. As you all know, the hybrid threats, as I also mentioned, was functional to react as the pressure put the instrumentalization of migration. But states could also could be entitled to react under other rules of international law, such as the rules that regulate the principle of non-intervention. This principle is provided by some treaties, but is also a well-set customary rule of international law, and it prohibits any interference in internal and external affairs of a state, provided that a matter is under domestic jurisdiction and coerce this state to carry out an action under political pressure. So many declaration of the United Nations General Assembly define the requirements for the principle of non-intervention to be applied, and I think it's relevant in this case because, of course, migration is a matter under the domestic jurisdiction of the state, and the political pressure that is made by instrumentalization of migrants cannot be denied. While I stress the relevance and the importance of the principle of non-intervention in this area, because international law also regulates the consequences that arise from the breach of the rule of principle of non-intervention, which is the discipline of countermeasures that could be applied in this case, but as well could be applied the limitations of the countermeasures rules, which are provided by the draft articles of the responsibility of states for wrongful acts. These limitations clarify the legal measures that could be legitimately be adopted, and countermeasures in particular should respect the principle of proportionality in international law. They should respect the protection of human rights and use codes rules, and should be for framing the phenomena I described above occurred in Belarus at the Greek border or at the fence between Spain and Morocco has legal implication if we use these conceptual tools, because we can also apply limitations and a clear, certain legal framework. But we know that this narrative has been replaced by another rhetoric, an aggressive language, the aggressive language of the hybrid threat paradigm, because it has been described, the situation of instrumentalization of migrants as an hybrid war, and the language of both the European states and the European Union often shift from instrumentalization to weaponization. Commissioner Johnson spoke about using human beings in an act of aggression. The Belarus president was accused of launching a hybrid war. Recently, in July 2024, Poland adopted the Homeland Defense Act, which broadens soldiers and police officers' rights to use firearms at the border. Such an aggressive rhetoric evokes the lexicon of armed conflict without invoking the parameters of Article 51 of the United Nations Charter. So there is a worrying and increasing trend to militarization of the border, but out of the requirement of international law. So the narrative of hybrid threats, instead of the narrative of the breach of international law, fuel ambiguities and takes advantage of the very indeterminacy of the hybrid threat paradigm. And this choice is not neutral, because as I told before, it has some important legal implications at the national level. Some emergency measures have been adopted. Latvia, Poland, and Lithuania declared the state of emergency. They suspended asylum applications. There have been violent pushbacks at the borders, ill treatments of migrants, forced return. So there has been a lowering of human rights level. Within the European Union, other consequences derive from the rhetoric of hybrid threat. which is shaping the infiltration of this language in the lawmaking. Because both the crisis and force majeure regulation and the amended Schengen Border Code institutionalize exceptional rules for situations labeled as migrants instrumentalization. And this is functional to reinforce an emergency-driven approach to migration, which is rooted in 2015 Agenda of Migration of Asylum, which treats arrivals to Europe, mass migration, management of migration flows as emergency, ignoring the structural nature of this phenomenon, and is functional to adopt disproportionate, exceptional, short-term solutions to manage migration. And also is accompanied by cooperation with neighboring states. So if migration management of flows is based on cooperation with neighboring states, when this cooperation becomes more fragile, states become more vulnerable to hybrid threats and are on the way to adopt more and more securitarian approach. So the hybrid threat paradigm distracts from the root cases of these attacks and generate tensions with member states that can escalate in increasing violence and militarization, but out of the clear legal requirement of international law. And this emergency-driven approach can be analyzed later in the day by Salvatore Nicolosi, so I know we can elaborate more on this point, but as this approach has infiltrated the lawmaking, one may be pessimistic about the capacity and also the political will of the European Union to be more proactive than reactive to instrumentalization of migrants. We will see the tangible effects of the adoption of these rules in the new regulation that will start to apply in 2026. But I can make some conclusive remarks by paying attention to some aspects. Even if we accept that migrant instrumentalization can fit the concept of hybrid threat, we must bear in mind that this kind of threat is fundamentally different from others phenomena. Like disinformation campaigns or cyber attacks or electoral interference, the instruments of this war without fighting are humans, protected by human rights obligation, of course, but also use coding rules. When the violation of the principle of non-refoulement is concerned, then it's necessary to come back to legal categories. Democratic states can counter this phenomena only by law, only by the existing tools. And it's necessary that legal categories, like the correct legal categories, are applied to this situation and take place in the narrative of both European Union and member states. At the same time, as also stated by the European Agency of Fundamental Rights, the measures to counter instrumentalization must not cross a red line. And this implies that the reaction has a limited duration and time, differently from what is happening at the Belarus border. To this goal, it is necessary that the requirements that are included in the crisis and force majeure regulation are applied and interpreted in a rigorous way. We know that some provisions of this regulation clarify that the adoption definition of instrumentalization must be reasoned. Any derogation must be limited in time, and the European Commission is involved in this process. So it is hopeful that all the actors involved apply law in a rigorous way. And all the other actors must search for a fair balance between the interests of states on the one hand and the imperative to protect human rights. Maybe today's conference and also the judgments to be delivered from international courts soon will help to shed light on this delicate and challenging equilibrium. Thank you.
Thank you very much, Francesca. And just before starting our first panel, I think it may be the case to just take it. If we want to open the floor, I mean, I don't know if you have any remarks on this presentation. Maybe I can make some couple of remarks, and I have a question for you and for the audience today. Just you see how comfortable we are in this beautiful place, and just feel free to ask questions. It's not a way of being judged or judging the speakers that we have on the floor. It's just a way of making interactive and enriching discussions for all of us. So this is a suggestion and invitation for the PhD students and the youngest between us. But now I resume my role as a president of this first session, the chair. I really appreciated your emphasis on the narrative issue. So the fact that most of the times hybrid threats really seem a refrain that is being used for a certain political purpose in very different fields. I mean, today's focus is on migration, but really pops into my mind other fields: critical infrastructure, economy, outer space activities, and cyber activity. This is sort of reframe. So it's us against them, and everything they do that can disturb in a way our activity can be framed as an hybrid threat. And there's a scale, I think, a spectrum in what you say. You correctly put the emphasis on the fact that sometimes we come across the term hybrid threat, sometimes it's hybrid attack, sometimes it's hybrid warfare. So hybrid, the adjective always says the same, but the noun, the term changes. So maybe this is also a change in the legal relevance of this concept. And another important thing that you mentioned, issues of reactions. So I always think that the best way, the best evidence, the best demonstration that a hybrid threat has worked is when the target state changes conduct, changes its behavior. So the fact that we are right now discussing limitations to human rights that maybe we didn't have in our minds 10 years ago, maybe demonstrates that this hybrid threat has reached its goal. I mean, the ultimate goal, the strategic goal of hybrid threats is to bring your opponent to do something that it would not have done in normal conditions. So to act against its own principle, to deprive them of their foundation. So when democratic states put in place some measure that, in a way, in conflict with democratic values and the core values of democracy, well, I think that this is a demonstration, the final one, that hybrid threat has worked, and it's reached its goal. But this leads me to the question. So this was just a background. You made an overview of the legal categories that come to the fore when discussing this particular instance of hybrid threats. So you discussed the principle of non-intervention. You made some references also to the act of aggression. So you are using, in my view correctly, some categories of general international law. So in your experience, keeping in mind what you have studied and your field of interest, do you think that these categories are really updated, up to date, or do we need to develop more, I'm referring just to general international law? Because we all know that intervention has some requirements, and there is mere interference between states. So do you think that the categories that we have are apt for this mission, or do you think that we need to elaborate some more? Just a reflection on that.
Yeah, thanks for this question because it really touches the point of this topic, I think, because as lawyers, we know that law can change and international law also rapidly changes and should adapt to society and necessity of actors that live in the legal order. But it is dangerous when this happens in this way. So without a clear legal framework, which is a solid basis for applying other legal consequences, because we have an undetermined concept, which is also accompanied by strict and binding rules and reactions that had legal impact on society and on the individuals involved. And so it is important that until hybrid attack becomes an accepted general rules, other rules are applied. Because as you said before, these qualifications of hybrid warfare attack is accepted only by NATO, some states, but these references are still sporadic, and the European Union. So it is sufficient for considering an emerging group. This is an interesting question, but I think that it could not be considered an emerging customary rules. We cannot consider these policy documents as providing legal concepts. So maybe non-traditional warfare and contemporary warfare is not up to date. But we must confront with traditional legal challenges now at the moment.
Thanks. Does anyone of you? Okay. I suggest that you may want to reach here, but just to make it possible to people connecting online to hear you loud. Yeah.
Thank you so much. It was really interesting. And I do have one question. So you said that instrumentalization of migration is very different from the other hybrid threats, but they're not happening in separation. So how would you, for when various hybrid threats are happening at the same time and there's instrumentalization of migration, what is, in your opinion, the effect on state responsibility as you outlined it in your presentation? Thank you.
Okay,
Yeah, I don't know if you want to collect other questions. If not, okay, feel free to answer.
Yeah, thank you very much for this question, because it also opens a long debate, I think. The main difference between this kind of hybrid threat and the others is that individuals are involved and human rights obligation apply. So this distinction is made by the draft articles on the state's responsibility for wrongful act. Human rights obligations are a limit in the legal framework about countermeasures. So if we apply that legal framework, it is clear that some rules should be relevant in this case. But if we don't pay attention to it and continue to fuel these uncertain ambiguities, it is impossible to be clear also about the legal consequences that could be acceptable in this case. So that's what I meant when I stressed that this choice of using this category it could be dangerous and functional to blur the legal category, to weaken international law. So I think that the legal framework on responsibility is clear, but is blurring for rhetoric, for political propaganda. It is worrying in this case. So.
Okay. So Anyone else at this stage? We have a full day ahead of us, so you'll surely have other occasions to ask your questions. So right now, I thank Francesca for this, presentation. It really helped to set the stage for our discussion and to build our blocks of today's discussion. So as we are, I would say, perfectly on time, even if we started a little bit late, schedule. So I think that we are not really tired and we can start for the first panel discussion. So I leave the floor to Lorenzo Conchamessa, who will be the moderator, and I invite the speakers to come to the floor and take the seat. Thank you very much.
You want to sit in the middle?
They are over here. So
That's nice.
and there we are.
Okay.
Should be.
So good morning, everyone. Thanks for being here, both in presence and online. So my name is Lorenzo Conchamessa. I'm an assistant professor here at the University of Palermo, and I'm very glad to be presiding this panel with those excellent experts. So exactly because of this, I will not take so much time. I will just give you a brief introduction of the topic of this panel. So now we're moving in the field of litigation, so how this narrative of instrumentalization of migrants made breach within proceedings that are pending before international courts and tribunals. And those courts are the European Court of Human Rights and the International Court of Justice. So chronologically, between 2021 and 2022, 3 sets of proceedings were instituted before the European Court of Human Rights against countries that have borders with Belarus, so Poland, Latvia, and Lithuania. And those states are accused of violating several provisions of the European Convention on Human Rights because they are accused of pushing back migrants towards Belarus and therefore to breach the obligations deriving from the right to life, the prohibition of torture and inhuman and degrading treatment, the prohibition of collective expulsion, in some cases even the prohibition of arbitrary detention, and the right to an effective remedy. So this is what's happening in the European Court of Human Rights. Those proceedings were relinquished before the Grand Chamber. The Grand Chamber held hearings in February this year. And at that time, the court informed the public that there were at least 30 other cases pending against those states concerning similar issues. On the other hand, we have a completely different type of proceedings because Lithuania in May this year lodged an application before the International Court of Justice against Belarus, which is accused of violating the protocol on the prevention of smuggling of migrants, which is an additional protocol to the United Nations Convention on the against transnational organized crime. So just to give you an idea of how this panel was imagined and how this panel and those proceedings show the complexity of this phenomenon, because in the same way as we titled this conference Migrants as a Sword or as a Shield, those proceedings also show that depending on the rights and obligations that we take into account, the same situation might lead to different conclusions concerning who is the victim and who is the perpetrator. So now I gave you a chronological introduction, and now some words about the content of those proceedings. So before the International Court of Justice, we have Lithuania, which presents itself as a victim of the breach of obligations deriving from the protocol against the smuggling of migrants. And Lithuania also accuses Belarus of violating Article 16 of this protocol, which obliges, while preventing and combating smuggling of migrants, to protect the rights of migrants, especially the right to life and the prohibition of torture and inhuman and degrading treatment. And we will go into the details of these proceedings with Dana Smaltz, who is a senior research fellow at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg. But then on the other side, we have also Lithuania, which is accused in front of the European Court of Human Rights of doing exactly the same. So Lithuania is accused also of violating those rights against the migrants that are pushed back at the border towards Belarus. Not only Lithuania, also Poland and Latvia. And we will go into the details of these proceedings with Daria Sartori. Daria is a human rights lawyer and executive director of the European Public Interest and Human Rights Clinic at the New York University Paris campus. And Daria is also the lawyer who is litigating the proceedings against Lithuania as a representative of the applicant. So we will have with Daria the perspective of the applicant, so of how the measures that Lithuania and in general states are taking to fight instrumentalization of migration actually affect the rights of migrants. And then in the end, also within the context of these proceedings, we will see what are the arguments that have been used by states, also by the intervening states in the proceedings before the European Court of Human Rights to justify their actions. So somehow they are excusing their actions, this action of pushing back migrants, because they consider themselves victims, again, of violations of their rights because of the instrumentalization of migration committed against them. And I think that this is a very interesting panel, also because the topic of my thesis was conflict of rights and obligations in international law. So I'm very curious to understand how those obligations and those rights can be reconciled and whether they can be reconciled. So I'm very happy to be here and to hear our excellent speakers. So Dana, the floor is yours.
Well, thank you very much for bringing us together in Palermo and for welcoming us so kindly here. And thank you really also for an almost genius composition of this panel. I'm very keen to discuss this in this relationship with also the cases before the European Court of Human Rights. I feel it's a great place to start because we're starting with the chronologically last case. And I have a very simple task, I feel, because we are talking about a case in such an early state of proceedings. I think it's a very interesting setting. Lorenzo already described that we have within 1 year proceedings where Lithuania is the accused and the accuser. I think what is also interesting, perhaps even beyond the immediate legal framework, is that with the ICJ proceedings, we have a case where a group of states beyond Europe is part of the discussion and perhaps therefore also part of the discursive surroundings of those proceedings. And of course, I'll come to that in the presentation. We have a completely different legal setting. So I feel there is a certain hope. Well, also from Francesca, we've seen that this is the situation with Belarus is not the only situation of where instrumentalization of migrants is discussed. But I think in some way there's a hope that with this proceeding under the smuggling protocol, one might produce a paradigmatic case how to really get hold of this phenomenon, because Belarus is also the foremost situation where instrumentalization has been so paramount and discussed. And yeah, I'll see if probably I'm not so hopeful that this will be successful in really finding the magic key to solve this difficulty of instrumentalization. I'll again, speak about a case that is at its very early stage. We had the submission of Lithuania against Belarus before the International Court of Justice in May. So I'll say a little bit about what's this case actually about, perhaps a rough first assessment of the plausibility of the claims. Again, will the case help tackle this broader phenomenon of migrants' instrumentalization? Yes and no. We'll talk a bit about the structure and purpose of the smuggling protocol and what I see as the possibility of instrumentalization without violating the smuggling protocols. Just to visualize, we're in a different setting here. We're before the International Court of Justice. We had this application in May, and we have a rough timeline given for how the proceedings will take place. So the claim are violations of the protocol against smuggling of migrants by land, sea, and air, which supplements the UN Convention against Transnational Organized Crime, the Palermo Convention, as we say. And the context is this instrumentalization of migrants, as we've heard about. The memorial of Belarus, so where we'll hear the counter arguments of this to the submission, is expected or is set for January 26th. And we have the counter memorial of Lithuania in July 26th. So this will be the times when we have a bit more at hand what the arguments of the parties are. And then, of course, we're just entering also into the phase where we'll eventually get a judgment. The legal basis, I think it's very important to see how this departs from the whole framework of human rights or also EU law that so far have been the paramount legal frameworks under which instrumentalization of migrants have been discussed. We're now talking about a legal setting where the purpose is prevention of crime. And this redistributes a bit how things are discussed. So the legal basis is this UN Convention against Transnational Organized Crime from 2000, which has these 3 additional protocols and one protocol that actually the case is filed under is the protocol against the smuggling of migrants. Now, the situation of jurisdiction is pretty clear, but comes with a little twinkle because there is a possibility of submitting disputes to the International Court of Justice under Article 20, but states can declare a reservation not to be willing to submit their disputes to the ICJ. Lithuania had declared such a reservation, but withdrew it formally, fully fine, but of course, very visibly with this intention of filing these proceedings in 23. So there has been a bit of prehistory before the submission, but there should be no difficulty of establishing jurisdiction of the International Court of Justice in the case. The submission, that's about 50 pages, mostly really talks about facts. So a large part is not legal argumentation, but describing in detail what they see as this instrumentalization, really using also this title. They start with the surge of illegal immigration at the Lithuania-Belarusian border. Until 2020, sorry, there were very few irregular entries in the low numbers, 20, 30, 40 per year, and then a sudden huge increase towards the end of 2020. And we know the political context of this, with migrants mostly coming from Iraq and then other countries in the Middle East, Asia, and Africa. And in 2021, just as a number, there were more than 4,000 irregular border crossings. The submission goes really in detail also in what have been actions of Belarusian state or non-state actors in this instrumentalization. So that includes the role of travel agency that are authorized to issue visa invitations, so really proactively engendering the entering of migrants to Belarus. and then transporting them to the border with Lithuania. This includes specifically for Iraqi nationals simplified visa procedures. The requirement that a return ticket, to have a return ticket for obtaining a visa was lifted. You already noticed those are things that not per se violate international law or any rules, but are seen in this context as active tools of engendering migration. There were those designated hotels in Minsk that provide accommodation and then organized transportation to the border. And the support to cross the border with Lithuania was first more passive, bringing people to the border, telling them perhaps where to go, but really not engaging with this border crossing as such, and then became more organized and proactive later. And there is a mention of the violence against migrants who decide to voluntarily return to Belarus. Now, we know from the other proceedings that those people are usually trapped and not accepted on either side of the border and actually face violence on both sides. But again, of course, that is something that clearly falls under violation. The legal argumentation is that this dispute falls under the scope of the smuggling protocol. In that sense, we have Article 2 that describes the purpose of the protocol. Article 3 gives the definition of terms. And Article 4 more narrowly talks about the scope of the protocol, and in particular requires that there is a transnational nature of the offenses and that organized criminal groups are involved. So Lithuania establishes that this is the case. I think we have no difficulties in seeing that this is transnational and also that there are organized criminal groups involved. And then Article 6 of the protocol requires the criminalization of migrant smuggling and also supportive activities like providing fraudulent documents. So this is the basis on which those claims stand, not yet the articles that Lithuania claims are violated. I don't need to read this, but to give you a bit the wording of those. So I think the statement of purpose is interesting because it gives us this framing again of what the protocol and the convention are about. It is to prevent and combat the smuggling of migrants and to promote cooperation. The protocol has a bit both sides. It has a side where the protection of migrants, so with the prevention of smuggling, really the protection of migrants is a huge part of what this is about. And we have this emphasized in Article 5, where also the protocol makes clear that migrants are not the target of this convention. They should never be criminalized for their actions, even if they participate in these irregular crossings. And on the other hand, we also have Article 18 of the protocol that speaks about the return of smuggled migrants. So in some way, the smuggling protocol is for migrants' rights and for migration control, both. And I think this is what in this proceeding creates a lot of tension. The Article 3 defines the smuggling of migrants, and I'll come to that in a moment in detail because I think there's maybe more difficulty in that than the submission by Lithuania seems to make of it. So the smuggling of migrants means the procurement in order to obtain directly or indirectly a financial or other material benefit of the illegal entry of a person into a state party of which the person is not a national or permanent resident. And we'll see the devil sits into the detail of material benefit, but perhaps not so devilish. And Article 4 again has this two components of transnational nature, organized criminal groups. So Lithuania's submission speaks a bit more at length about the criminal groups, which are state-owned entities such as Belavia. Well, don't need to read them out, but really mention those specifically. State agencies, but also private entities that are involved in these organized travel of persons arriving in Belarus to be transported to the border. Now, the submission is very brief on what actually is this a case of smuggling. And in some way one might say, of course, that's the very thing that the people are brought to the border, irregular entries is enabled. So what if not that is smuggling? But in some way, I think it stands square to the purpose of the protocol, where the states are agreeing to prevent criminal actions of people who want to benefit on the exploitation of migrants. And the what I've written here in the lower part, I think smuggling is situated between, or is different from, on the one hand, humanitarian support, so without exploitation is not smuggling, and on the other hand, different from trafficking, where people are change location without their consent. So smuggling is built on this part of exploitation, and I think in the term instrumentalization, it's clear that the purpose here is different, because the exploitation of migrants in some way is a collateral damage almost, because the main purpose is this political destabilization. So the target are not the migrants, the target is the European Union or other states. And in that sense, going back, I believe that we might have more of a discussion to do about this material benefit. There are, of course, actors that benefit materially. So some, especially of those private entities, will receive sufficient financial compensation from the Belarusian state for their participation in this whole endeavors. But the overall, let's say, if we look at what's going on in its totality, I don't think material benefit is the core. And in that sense, there might be a necessary discussion. But you can also think that perhaps this is not the argument that Belarus will make in its kind of memorial, saying, well, actually, our purpose is political destabilization. We are not a criminal gang. We are a state after all. So we'll see. I'm not sure it will actually play out in the proceedings. I'm very curious if something about this will be discussed. But to me, this is a core point where this stands a bit square with the logic of the protocol. Now, sorry, I just passed over this point a bit too quickly. There has been a history of discussing what this material benefit is about. It's not defined. And we have, I'd say, an indication that this should be understood broadly, but this might not go as far as really taking into material benefit what is political destabilization. But again, that is up for discussion. The submission claims that several of the subsequent articles of the protocol are violated. And I do think once we accept that we are looking at a case of smuggling, those are not so difficult to establish. So this concerns Article 10, the exchange of information between states. Of course, Belarus has not been cooperating with Lithuania about preventing irregular entries and exchanging information in that sense. The border measures to prevent the smuggling of migrants not happening. The control of documents precisely not. And further preventive measures against smuggling, including, and that's the last point, measures to prevent the violations of migrants' rights. That too has not been part of what Belarus is doing. So in some way, I think the case could go through very easily on those articles. I'm coming already to the end, and that point that I raised, that will this, beyond being successful in establishing that there's been violations of the protocol, will this be successful in the sense that it provides this tool of grappling with the instrumentalization of migrants? And I think for that, we have to see the logic of these frameworks, and we have to see the logic of instrumentalization. So I think the smuggling protocol, as the Convention Against Organized Crime, are really about protecting the victims while also being interstate agreements. So in some way it protects the other state from the effects of organized crime, but also the victims. It is not an instrument primarily directed at migration control, and I think it can't be easily made such one. But it also has this dimension where it really aims to prevent irregular entries. Now, I think the main difficulty lies in the fact that instrumentalization does not depend on the irregularity of the entry. So we now have a situation where this has been operating largely on irregular entries, where people are crossing sides from official border crossing points. But you could imagine a scenario where the Belarusian conduct is fully in line with international law because there is no prohibition on lifting visa restrictions, on allowing people to enter Belarus without a return ticket, and in some way also not in allowing them to go to the border, as long as they do not cross irregularly but apply for asylum at a border crossing point. And then we have those other legal frameworks that we will hear a lot about, that there is an obligation under EU law to accept asylum application. Yes, it can be limited to certain numbers, perhaps under certain conditions. There can be a situation of crisis, mass influx, etc. But there is simply no possibility to fully close the door, fully exclude those applications. Same under the European Convention of Human Rights. We've had those cases against Poland that clearly said this rejections of asylum application, this unwillingness to even look at the individual case and just say we don't take applications here, is a violation of the European Convention on Human Rights. So in some way, the possibility of putting pressure on a state by bringing migrants to its borders is not dependent on smuggling. And Diego said that the human rights are the vulnerability of the European Union. So in some way, really, I think that puts the finger on what's the difficulty and why finding that Belarus violated the smuggling protocol might be important also in preventing the exploitation of migrants that goes on with this, but it will not solve the issue as such, in my opinion. So in summary, I think it will be another really interesting forum also for establishing facts. Beside a legal decision, such a court proceeding is an opportunity where really rigorous fact-checking and publication is done. And I think this always helps bringing transparency into what's going on. We have to wait for the further proceedings. So my very preliminary comments on this case are in ignorance of what states might argue, which might be also unforeseeable. And I do believe that it will not solve the issue. Thank you very much.
Thank you so much, Dana. And I mean, I think it's very important what you stressed about the fact that this is not a human rights treaty. The aim of this treaty is different, is the prevention of crime, transnational crime committed by non-state actors. And just an observation came to my mind, also thinking about what states could argue. And this will also bring to our second presentation on Lithuania being on the other side. So I will just make an observation. So my idea is that actually it was risky for Lithuania to bring this case. And my question is whether Belarus will make a counterclaim against Lithuania, because actually this is a treaty aimed at preventing and combating smuggling of migrants committed by non-state actors. And Lithuania was very careful in drafting the application, and it stated that there are criminal organizations involved, but actually Lithuania is accusing Belarus of committing as a state smuggling of migrants. And actually the measures which fall within the scope of application of the treaty, prevention and combating smuggling of migrants, are the measures taken by Lithuania. And Lithuania, while combating smuggling of migrants, is obliged under the same protocol to respect human rights. So my idea is that probably this will lead to some findings of violations against Belarus, but actually Lithuania finds also in a very delicate position in those proceedings, because the protocol is clear. This protocol aims at preventing and combating while respecting the rights of migrants. And we know that probably Lithuania is not, and this brings us to the second presentation by Daria Sartori, who is litigating against Lithuania. So Daria, the floor is yours.
Thank you so much. Can you hear me?
Yeah.
Yes.
Clear and loud.
Wonderful. Wonderful. I don't have a presentation, so there is nothing to show on my side. I hope that everybody can see me because I don't see the room, but
Yeah.
yeah, okay, perfect. Thank you very much. So thank you very much, Lorenzo, and thank you very much to the organizers and promoters of this conference. I'm really happy to be able to participate, although remotely. And Lorenzo, by the way, I saw that earlier someone raised a hand among the online participants. So just a reminder for later if you take questions to also check on them.
Perfect. Thank you.
Okay. So I'll dive right in. My role today is to talk to you about the cases pending before the European Court of Human Rights at the Grand Chamber level. So the structure of my intervention is as follows. I will give a quick overview of the origin of these 3 pending cases, and then I will focus especially on the arguments that were developed by the parties in the case COCG and others versus Lithuania, because this is the case in which I represent the applicants. And I will focus specifically on the arguments developed around the topic of instrumentalization, seeing as it is today's focus. So as regards the overview of these 3 cases, an overview or the origin of the 3 cases, you have already has already been covered the situation of the crisis of the EU external borders with Belarus, and it will be covered even more precisely, I guess, by Alexandra in the afternoon session. I just wanted to add a couple of extracts from civil society submissions, because I think they are relevant to really understand what was going on in 2021 and what is actually still in part going on at this border. And I know that there is civil society attending also from the interested states in attending online. So I'm sure they might also want to give some details. But there were individuals, especially in the winter of 2021. There were hundreds, thousands of individuals forced to stay at these borders. These are green borders, so these are forests, there are swamps, and people had to stay hidden to avoid violence from both sides of the borders for weeks, for months, exposed to extreme cold, heavy snowfall, and a lot of them suffered hypothermia and risked injury and risked their lives. So just to give you some extract from Human Rights Watch, for instance, following a Polish pushback in March, this was already 2022, a 30-year-old man from Yemen said that Belarusian border guards forced him and 3 others from Yemen and Iraq to stand in knee-high water in a river for 1 hour in freezing temperatures, and then forcing them at gunpoint to swim across the river to Lithuania, and 1 man drowned, while another was swept away by the river and never found. There have been reports by MSF of persons who have been burned alive by the Belarusian border guards. Several cases reported by the Lithuanian Red Cross, MSF, and other of migrants losing their limbs, including 1 person both legs after suffering frostbite for being stranded in the forest at those borders. And lastly, I just want to check this 2024 report funded by the European Union and prepared by a number of organizations, including Human Constanta, which is a Belarusian organization operating in exile, and Sienos Gruppe and the Ocalenie Foundation. They give the numbers of border-related deaths occurred between December of 2021 and end of March 2024. There were more than 100 people who died. So this is for us lawyers working on the cases, this was more of a humanitarian crisis. And I know it's the same for the civil society organizations working on the ground. So our focus, I guess, has always been rather on the humanitarian crisis than on the instrumentalization aspect. And I mean, The reason why an Italian lawyer came to be in charge of leading the litigation against Lithuania is because when in 2021 this situation exploded, I was just starting to lead this project that I run, which is called the Rule 39 Pro Bono Initiative, which supports civil society in bringing cases to the European Court of Human Rights, especially with requests for interim measures. Now, I guess that a lot of you know what are requests for interim measures, but for those of you who don't, these are requests lodged before the European Court of Human Rights under Rule 39 of the Rules of Court. And these are urgent requests, which are aimed at a quick reaction from the court. It can take even a couple of hours, sometimes a couple of weeks, but it depends on the urgency of the case, to get a reaction from the European Court to order a state to do or not to do something. So all these cases brought to the attention of the European Court concerning the border crisis with Belarus, they were all brought firstly with requests for interim measures before the European Court. It was the Polish lawyers and Polish civil society who reacted massively to the crisis, and they were really great in organizing themselves and lodged interim measure requests for at least 200 or even more, I think, asylum seekers and foreigners stranded at the border, and those that were notably being pushed back once already on EU territory, being pushed back to Belarus. So the objective of these interim measure requests was especially to prevent the removal from territory in violation of EU and European Convention on Human Rights law. So in this context, I reached out to civil society on the field, and I was, redirected to Lithuania, because in Lithuania there was a less, the situation was only starting, and they were a little less at the time organized than Poland. So I offered my support to civil society there, and I supported several cases against Lithuania, including the one that later turned out to be the one selected by the Grand Chamber, by the court to be relinquished to the Grand Chamber. In this case, I've been working on it since 2022, and for me, it has been emotionally also very, heavy to deal with, because it concerns 4 asylum seekers from Cuba. They were really young at the time. They're still young, they're in their 20s, and they fled political persecution, and they are also, I don't know, they were not a typical type of foreigners present at the border at the time, I guess, because they came from Cuba, not from the Middle East. They were highly educated, and they were not joining big groups. They arrived in Belarus of their own accord, completely unconnected to the reasons, to the situation of instrumentalization that was, to the easing of visa restrictions that Belarus was provoking for Iraqi nationals and other Middle East nationalities. They came to Belarus because it was a long journey, but basically they did not need a visa, because Belarus and Russia, they are both allies of Cuba, so Cuban nationals don't need a visa to enter those countries, and they were seeking asylum in Europe, and they didn't know didn't know that a crisis was taking place at that moment in time at the EU external borders with Europe. So they came in full, ignorance of the whole situation, and the first pictures of them, crossing the border were like they had these trolleys, and they were carrying their luggage as if, they were so confident that they would just walk on European territory and be allowed to apply for asylum. And in fact, what happened was that they met a nightmare. And what they repeatedly told me is that we were escaping from a dictatorship, and we came to Europe, and we thought that we were going to meet finally human rights, and we were actually beaten up, sent back to Belarus, and then stuck in a game of ping pong between borders, with Belarusian on one side beating them and sending them to Lithuania, forcing them to cross back to Lithuania, and Lithuanian authorities ill-treating them and forcing them back to Belarus multiple times, in a moment in which it was like snow, and they ended up, in the woods for weeks. And in the end, when they finally were allowed to stay on the territory and allowed to lodge their asylum request, thanks to an interim measure request that we presented to the European Court of Human Rights, one of them was diagnosed with 2 frostbite on both feet, and she could not dance anymore. She was a ballerina in a previous life, you know, and all the others had heavy damages. And of course, these are minimal damages compared to those that other people have suffered. So anyway, and when this case came to us, you know, we thought, okay, this case, as all the others that arose from this situation, are not really exceptional in a way. In light of the court's case law, they are not really exceptional. The court has already multiple times asserted that Article 3 is an absolute right, that an increasing influx of migrants does not release the state from their human rights obligation. The state has taken a pretty debatable position in NDNT concerning Article 4, Protocol 4, but, you know, we can work with that because we have a different situation here. At least in our case, you know, it's a small group, they were peaceful, there are a number of elements distinguishing them from NDNT. So we kind of thought, okay, this is going to be an easy finding, you know, of a violation for the court. And in the beginning, it looked like the court was going to treat this case and the others as any other. They asked a number. The case went through all the stages of, you know, attempt of friendly settlement, exchange of observations between the parties. These were before a chamber, so a regular instance of the European Court, and the questions of the court at this stage were very factual. You know, the court asked questions to the parties, and the questions were very factual, where, I don't know, were the applicants on the territory of Lithuania in the dates they allege? Was Article 3 violated because of the pushback from Lithuania to Belarus? Stuff like that, right? So it was a pretty standard case in a way. And it started in 2022, and until 2024, you know, it was ongoing in a regular way. And then, in March 2024, I remember it was shortly before Easter, the court wrote, say, to both parties, to us and the government of Lithuania, saying, we are considering, the chamber to which the case has been allocated is considering relinquish it to the grand chamber, which, just a short procedural note, you know, the relinquishment is not a referral. So in the case of a referral, there is already a judgment from a chamber, and one of the party asks to the court to bring the case up. Let's say it's very improper, Lorenzo will kill me to say so, but let's say it's a kind of appeal. Instead, in the case of a relinquishment, which is the present case, is the court of its own motion who decides that a case needs to rise up to the Grand Chamber. And it can be because, according to Article 30 of the Convention, because the case raises a serious question affecting the interpretation of the Convention, or where the resolution of a question before the chamber might have a result inconsistent with a judgment previously delivered by the court. So at this point, you know, the optimistic in me thought, okay, this is great. Maybe this means that the court might be persuaded to overrule NDNT versus Spain. So I wrote 10 pages on how this would be the perfect opportunity for the court to overrule NDNT versus Spain, whereas the Lithuanian government wrote a few lines saying that this was the perfect opportunity to address the topic of instrumentalization of migration, right? So the court did, the court would have relinquished the case anyway, even without our observations, because it's really like more a matter of they inform you they've already decided, but formally they give you the opportunity to say something about it. But anyway, it confirmed the relinquishment. And so then a whole work started around, you know, also with the representative, this was the first case that was relinquished, and then came the relinquishment of the cases against Poland and against Lithuania. RA and others versus Poland, and HMM and others versus Latvia, sorry, not Lithuania. So of course we had a chat with the other representatives, and there was a whole point that we decided about, you know, agreeing on the language that we were going to use in our submissions and on the attitude that we would have towards the topic of instrumentalization. So we refused, all of us refused to use in our submissions terms such illegal migrants or hybrid warfare, because we thought that the important in this case was to put the accent to challenge the narrative about instrumentalization, to say it was a humanitarian crisis, like human beings should be at the core of proceedings before the European Court of Human Rights, and human beings were being mistreated badly by both parties. So yes, of course, acknowledge the challenge of migration management, but showed that this was by far not the worst crisis faced at an EU border. If I think about the 2015 crisis and what Italy faced even at the time, I mean, here we are talking about numbers that are ridiculously low in comparison. So this is our choice, let's say, and the legal arguments that we had to develop were different in the Grand Chamber submission than before the Chamber, because the Grand Chamber asked different questions. And I want to share, not all of them, there were so many, but a couple just to give you a hint. You know, before we had very factual and legal questions in a way, and here we had questions such as, if the applicants had been made to cross the border by the Belarusian authorities at any point, or the parties are requested to provide information about the context in which the events took place, in particular, the actions taken by authorities of third states, and whether there was a systematic practice carried out by any third state's authority of pushing foreign nationals through the border. Or even, and this was the one that I loved the most, the parties are asked to comment on whether any actions taken by third states may affect, and if so, how, the contracting states' obligations under the convention. In particular, Article 3, Article 4, Protocol 4. So the respondent government did their job, of course, and their argument was very much political. So they wrote and they delivered it can be seen, it's publicly available. They delivered a speech on the day of the hearing that was very much focused, on the narrative of we are safeguarding all of Europe, against what we all know is a threat coming from certain states that don't need to be mentioned, but it is not only Belarus, right? So basically, we are this last bastion of democracy against totalitarian regimes. This is their narrative around this. And saying, that these groups of migrants coming in represented a threat to national security because we don't know whether it was impossible, to process all these numbers. You couldn't know whether there were criminals against them, whether there were spies amongst them, and claiming that the vast majority of them were not genuine asylum seekers and such. On our side, of course, we went as much as possible on the facts and legal case law of the court, which is actually pretty much established on all these points. I mean, from a certain point of view, it seems really weird, to decide to relinquish this case to the Grand Chamber from the purely legal point of view, because the case law is clear. There have been multiple Grand Chamber judgments saying that migration issues cannot influence the way that human rights are protected, cannot modify the guarantees, And of course, there are possibilities to derogate to the convention, but these states didn't derogate. And also, in any case, any derogation wouldn't have affected Article 3 complaints. So there are some points that are really like, that we insisted on. We also insisted on the fact that it was not like to the question of whether actions by third states may affect the contracting state's obligation. What we said was that contracting state's obligation under the convention cannot be sidestepped or diluted on account of a third state conduct. On the contrary, the actions of Belarus might inform the obligations of Lithuania, Poland, Latvia under Article 3, because under Article 3, they knew that sending people, not necessarily asylum seekers, but any person back to Belarus meant sending them to death, okay? So we try to turn, the narrative around to focus on the human rights, on the people at the core of this. And of course, I guess that in COCG and others, so Lithuania case, we also have, the good argument that the applicants have been recognized as asylums, as refugees in Lithuania at the end of the events. So they were at the time of the events genuine asylum seekers, even though I maintained throughout our submission that it doesn't matter if you are a genuine asylum seeker or just an economic migrant, you're still entitled to basic human rights. But so to conclude, the whole exercise, I guess, was to try to refute refute the narrative of instrumentalization, because this is not a forum to talk about instrumentalization. The European Court of Human Rights is the focus to talk about the human rights of people. And something that I said at the hearing that I want to say to conclude now is that respecting human rights does not make us weaker. It actually makes us stronger, because this is why, this is the only leverage that we can have as European states to say that we are better than others, because otherwise we just become like them. And then what is the point of pretending that we are better than others if we don't provide respect to the human rights obligation to which we subscribed? There will be much more to say, but I'll give back the floor to you, Lorenzo, and to Grazi now. I'm sure we'll continue the discussion with very interesting thoughts. Thank you very much.
Thank you. Thank you so much, Daria, also for sharing with us the story of how you met the applicants, how you built the case. This is something that as academics sometimes we overlook, and also the facts of the case, which are very important. So not only the legal questions, but also the facts and the stories of those people behind the cases. So thank you so much. And I completely agree with you that we all hoped that these cases could have overruled ND and NC versus Spain. And now we're here afraid that we might actually overrule Sering versus the United Kingdom and go back without the provision of non-refoulement and the absolute nature of the provision of refoulement as we know it. And also what you said about the case not being really exceptional is true. The case law of the court was clear, was established. We were all sure that those cases were going to be decided in some way, and then something happened. And I think that something that happened is also very much linked to what our next speaker will tell you. So the extraordinary operation of pressure that has been put to the court by the states parties to the convention that are using, as you said, the convention and the European Court of Human Rights as a forum for discussing topics that are not the topic of proceedings before the court. So we will now go to our last speaking, Grazina Baranowska. She's a full professor of migration law and human rights at the Nuremberg University, and she's also a member of the United Nations Working Group on Enforced and Involuntary Disappearances. And also Grazina participated to those proceedings because she submitted a third-party intervention. And Grazina, thank you so much. The floor is yours.
So thank you very much to the organizers for this wonderful conference. And it's also a personal pleasure to be with Dana and Daria on a panel and to be able to engage with the two of you. And I do think that we have this, all of us are speaking to the same topic, but we do take different approaches. So from Dana showed us a lot of what Belarus has done. Then Daria brought in the perspective of the applicants. And now there's also a third kind of party to that context, a triangle. So there's Belarus, there's the migrants, and then there's also the states that where the migrants arrived. And what I will try to do is to shed a bit light on their obligation and how that looks out. So here is kind of where my starting point is for today. So instrumentalization of migration is such a broad term that covers both lawful and unlawful measures, and that has already been mentioned before by Dana. But those different practices, they entail different responsibilities and liabilities, obviously. So there cannot be one effect on instrumentalization of migration for targeted states. So we always need to look at the measures, what that actually means if we want to talk about effects. And lastly, I actually do believe that certain instrumentalization measures may have consequences for human rights protection under the convention. So there is a space for that would need to be discussed, but to understand that, we need to understand which measures are we talking about and which is threat enough to influence the obligations of the state. So my presentation today is divided in two parts. Firstly, I will talk about the pending cases, and I will mostly highlight which arguments have been stated in the pending cases from the perspective of not only of the states, but what exactly does it mean? kind of this instrument, what does it mean for obligation of the state? And then in the second part of my presentation, we'll take a step back and say, well, there are also other measures. So which measures would then influence potentially? What I'm not able to do today is to give a response, right? I will not say, well, two instrumentalization measures, that's what we should do. And I also don't think that we can give this answer. So we can give an answer to one specific instrumentalization measure or to one specific context, but we cannot give an answer in general to all of those measures. And I used two terms already a couple of times, so I wanted to come back to them. So firstly, there's the instrumentalizing state. And in this context that we talk about, it is certainly Belarus. However, it has been stated numerous times, including during the hearings, that it's also Russia, which legally speaking, I don't really think we can say. That's why there is a question mark. Russia is important because Finland, who was also part of the proceeding, is arguing that Russia was instrumentalizing Finland. So there we have kind of an additional part, but it was stated also in the courtroom as well. So this plays out here too. And then we have the three targeted states. So when I will be talking today about an instrumentalizing state, that's what I mean, and targeted state, it's the states that are directly targeted by instrumentalization. So firstly, on the case, as Daria has mentioned, we have three applications that actually do differ. So it was not a clear-cut choice to put them together and decide them together. There's really different underlying causes in all three of them. There was a joint Grand Chamber hearing on the 12th of February, and the arguments that I will summarize now stem from that particular hearing. And before I go to the arguments, I wanted to read out two quotes from that hearing. So firstly, the present case is unprecedented. Until today, the court has not examined cases even remotely similar to the one presented today. And this was the Latvian agent. It was kept repeated by agents in various forms. And then the Commissioner for Human Rights said, in the case of the behavior of Belarus, we see nothing new. So we had kind of this discussion on, is it new, is it not new, and very strong opinions on that, on both sides. And how I see it, actually, the court decided, well, that it's new, right? So the very fact of having it, the relinquishment, which is rare, and it concerns a serious question affecting interpretation, it shows for the court, it is new. They do consider there's something about it. The very fact of the hearing also shows that there is something new. And again, the fact that all three cases were heard during the same day, right? So it showed that there's something so similar in those three for other different cases that we need to talk about them in exactly the same context. There has been, of course, very similar violation in exactly the same place already before. So we spoke already about the judgments against Lithuania and Poland, but obviously there are new things that have happened in 2021. So the two core issues would be firstly the Belarusian involvement, which we've heard Dana explained that it was really far-reaching. So it was really their initiative for this to happen, and a huge increase of arrivals. And the huge increase means huge in percentage, but you saw the number, but I think from an Italian perspective, numbers are really kind of a cause for laughing. It was 4,000 people in the very first year in Lithuania. It was for 2.5 years, the first 2.5 years, it was about 20,000 people in Poland. Poland is a country of 40 million people. So it's really kind of the vast increase is percentage to what has happened before, and not that there is a big number of people. And then I would argue, and it has been said in the Grand Chamber as well, that a huge new aspect was the full-scale invasion. But, and this is a big but, the full-scale invasion happened in February 22. So if we even say it's relevant for the cases at all, it could only be relevant for the Lithuanian case, where the pushbacks were still happening after the invasion. So the case against Poland and the case against Latvia, the full-scale invasion was irrelevant because all the facts have happened before the full-scale invasion. So while in the courtroom, the full-scale invasion came up again and again, at least for those two cases, it's absolutely irrelevant. So now coming to the arguments made and the discussion, and I discussed that a bit more in detail in a post on Strasbourg Observer that you have a link here. So what I think is important is that the states did not argue that instrumentalization of migration justifies annulling or temporarily suspending the right to asylum. They were asked explicitly and they said, no, we cannot annul or temporarily suspend the right to asylum. And all of them said, we did not, right? All of them said, we did not do that, and this cannot be done. All of them said, it would not be different if we had derogated. They said, because we actually were in line with the convention. So derogation was not raised, should not be an issue. And this was said by the states themselves. What they did say, and what I think is actually a very weak argument that I don't think the court would at all engage with, is they suggested to the court to employ Article 17. Looking at the case law in Article 17, this is so unlikely that I will just skip this one argument and go to two arguments that I actually think that the court will engage with. So firstly, all of the states called for something which they called context-specific interpretation. So they said, well, you cannot assess those violations outside of the context that was happening at the border in this particular time. What they did not say is, what actually does context-specific interpretation mean? So they were kept asked by the judges about it. And what came out is that the court should apply the established criteria, meaning the criteria that are already there, with particular rigor. What does that mean is really hard to say, but kind of to say, well, you should be more strict in this context than you would be in others. And that this unculpable conduct test that Daria talked about should be applied in this particular instrumentalization context, because as the people participated willingly in the instrumentalization of migration, that already made them culpable of their own conduct. As you can see, the problem with that reasoning is that the basis for starting the unculpable conduct test at all is that there have to be an existence of legal means of entry, and the legal means of entry into all of those three countries is one of the issues that is disputed in the cases. So the state says there was access, all of the applicants say there was none. And then what I found extremely interesting is that there was one of the judges who asked all the states one particular question, kind of pushed them. So some of the representatives got more than one question on that topic, on the distinction between positive and negative obligations in this context. And the responses by the states were not very good, but the question was very good. And the judge seemed to be very convinced of that idea. And that could be something that would be picked up in that particular context, saying, well, if a state is targeted by instrumentalization of migration, then some of the procedural rights could be differentiated. What is kind of relevant is that looking at the case law of the court, this could only affect the modality of the risk assessment and not the fact of conducting the risk assessment. So this would be possible procedurally and looking at the case law of the court, but this is how far the court could go kind of in interpreting that without changing zoning or whatever. But this is kind of could be a step that I could imagine from the discussion being happening. So now going a bit kind of to other instances of instrumentalization. So we tend to think of Belarus as the instrumentalization context of a new phenomenon or something new, which actually is absolutely not the case. And there is excellent research in the fields of international relation and political science on instrumentalization of migration. However, there it is called coercive engineered migration. There is a wonderful book back from 2010 where Kelly Greenhill shows over 60 examples of coercive migration since 1950. So showing that, well, there's nothing new. There are examples that are extremely similar to what has happened with Belarus. So this has happened before. States have reacted to it in various ways, right? Some states have reacted similar as Poland, Lithuania, Latvia. Others have reacted differently. So we can see that this is a trend. There is also increasing research specifically on Europe. But what can we learn kind of from history or from looking back at those cases? that state are instrumentalizing so many different things. So firstly, you can instrumentalize your own citizens, the departure of your own citizens, by allowing them to leave or not allowing them to leave. This is actually, in many regions, it's the most regular instrumentalization measures to say, well, today, all the citizens that want to leave can leave. And then thousands of people are leaving, and then you close the borders again. Or asylum seekers, that was the case here, but also recognize refugees. So you would see states that have refugee camps that for some reason then instrumentalize the departure of them. And from a legal perspective, of course, all of that is different, right? So it might raise different questions. States also use persons that are already on their territory, and just as Belarus did, with the majority of the people, not all of them, certainly, but with the majority of them, deliberately facilitated their arrival. So that is also legal under international law, but it's a different perspective. States can also encourage, they could facilitate, or they could coerce. So the engagement of the state in that is also different. And when we talk about state responsibility, this is of course also relevant. What exactly was the role of the state? And there are different degrees of acknowledgement by the instrumentalizing state. So this is something that we don't discuss a lot in the Belarus context, because Belarus is right out in the open saying, yes, we did that. But what if Belarus wouldn't? What if Belarus would be saying, well, we have no idea why those people are there? So would that be of any different? Would that make any difference? And this is also what's happening in many places. And then lastly, and not least importantly, there are very different measures employed in instrumentalization, some of them being lawful, some of them being unlawful. So kind of the core responsibility, of course, in instrumentalization lies on the instrumentalizing state, right? So this is kind of where it happens. But when we take the international human rights law perspective, then we're actually mostly looking into the effects on obligation of the targeted state and effects on the rights of the migrant. So this is kind of where we actually have three actors, but for example, at the European Convention of Human Rights, we would only look at two of them, at the relations between the two. At the Grand Chamber hearing, the states were very clear, migrants were not the threat. They kept repeating that. They said they came peacefully, it was not the threat. They said it's Russia and Belarus that are the threat. And Finland repeated that kind of in the context of Russia. And the core argument was about the threat that it's broader security concerns that stem from Russia and Belarus, and those broader security threats. So again, the full-scale invasion was mentioned, hybrid threats, disinformation, all of that. They justify restriction on human rights. So this was kind of where you would see this argument being made. So you bring together kind of the different actors in that. Is international human rights law actually capable of bringing this all together is kind of the big question in the room. But can kind of from a human rights perspective, all persons crossing in a particular context be restricted? The rights of, can we say that if you're coming in that context, we're restricting your rights? And if so, is the awareness of the migrants that they were part of an instrumentalization process, is that relevant for restricting the rights? So coming back to Daria's Cuban example, if the Cubans did not know that can we still restrict the right? Is this still their own culpable conduct or not? But if so, how do we assess awareness, right? Then we would ask people and everyone would say, well, I did not know. So this is, it's not an easy question if we really want to restrict the rights. And then I want to shortly show 3 examples where I think that actually real questions to me would arise on how to restrict the rights or not. So firstly, if the 2 states, the instrumentalizing state and the targeted state, were at war with each other, and then there would be instrumentalization of migration. This is not the case in this situation. No one is at war with Belarus, and none of the 3 countries are even at war with Russia. So it's not relevant for this context. But if it would be a war and instrumentalization measures, I don't think that anybody would argue that the state has full obligations after that. So here we would have a situation where we would need to kind of weigh in and see how can the obligations of the states be interpreted in the context of a war with the state instrumentalized. Less complicated, but also but more realistic. What's happening if there's a violation of the R space with military drone while facilitating a irregular border crossing? So this is absolutely non-hypothetical, right? There is a drone coming over. Russia is saying, well, it's not our drones. Everyone knows it's Russian drones. And at the same time, there is instrumentalization. Is there any effect, right? Would we connect those facts? Would we say, well, that allows for the restricting of rights, that has any effect on the obligation of the state? And lastly, maybe most complicated, acts of sabotage. So this is a situation from a couple of days ago in Poland. There was a destroying train tracks by two actually Ukrainian citizens. One of them already convicted in Russia, in Ukraine, for sabotage, for which he was paid by Russia. And it happened last Saturday, and what makes it extremely interesting is that they actually crossed into Poland from Belarus in September this year. And after doing this act of sabotage, they went back to Belarus. So here the link to Belarus is extremely clear. The link to the root of instrumentalization is extremely clear, but should it have any effect on what the state does on this particular route, or shouldn't it? And those are questions that I think if we want to take that topic serious, we need to ask ourselves and also position ourselves too. And there's no straightforward answers to those questions. So coming back kind of to my main point, I don't think there's one response to instrumentalization of migration and to the obligation of the states, but I do believe that certain instrumentalization measures may have consequences on the human rights protection under the convention, and I don't think that the instrumentalization measures that were employed back in 2021 would have such consequences. But I do believe that things that have happened after that might have consequences that we might need to look at and to think about. Thank you.
Thank you so much, Grazina, and thank you for sharing those different arguments and perspectives that have been used by states. I think this shows that sometimes states do not know in which context some arguments are to be used, because, for example, you mentioned Article 17, the invocation of Article 17, you mentioned the exception established in NT versus Spain, where there is the culpable conduct of the person. But on the other side, Lithuania is invoking between the International Court of Justice a treaty that says that the smuggled migrant cannot in any way be punished or penalized for having been smuggled. But then on the other side, you say, yeah, because a third state is abusing the rights of migrants, that the migrants should have his case declared inadmissible. So I really think that all of this needs really to be categorized on what are the correct arguments and in which fora, in which places those arguments should be used. And I also don't have the answer, but I really think that there can be a way to reconcile all those obligations without denying the rights of the migrants that are involved. So thank you to all our speakers, and now we will open the floors for questions. Daniel. And then we will also take the questions from the friends that are online.
Thank you very much for a brilliant presentation. And I have a question of Dana and Grazina. And Dana, thank you so much. I also appreciated your paper on the topic of the presentation today. Which I found really on point on the application. And I found very interesting when you say that the smuggling protocol must be in a broader picture because it provides obligations for states for managing smuggling of migration, but also protects migrants' rights. You mentioned Article 5 of the protocol, but the smuggling protocol also provides for Article 16, which establishes some protection measures. And I just wanted to ask you if you consider that in your analysis about the way in which this application could be also counterproductive for Lithuania. And from this perspective, I agree when Lorenzo said that this narrative is not only legally questionable, but also counterproductive for the actors, the active state. And to Gratina, I would like to ask if the definition of the instrumentalization of migrants, which is now provided by EU law, contributes to generate uncertainties about the scope of this phenomenon, and this is also an impact of the European Convention on Human Rights context, because the court interprets the legal obligations in light of other instruments, because this article in the crisis and force majeure regulation does not establish a threshold and a clear distinction between lawful and unlawful acts. So I would like you to elaborate more on that. Thank you.
I would say we will take at least 3 questions, and then we will make a round of responses from our speakers. So Daniel also wanted to make a question, and then we will take a question from the people online.
Thanks. I have 3 short questions, and they all relate to the Lithuania case, but I would actually pose the question to all 3 speakers, because I think all 3 are willing to answer. The first is this distinction between positive and negative obligations. I haven't followed the hearing, so I don't know any detail. What would the outcome be? Would the outcome be that if Lithuania, Poland, or any other state does not allow admission to the territory, they have not violated the convention? So Sterling stays intact for people who are on the territory, who are expelled, but people who are denied admission, there is no violation. So what would the outcome be? Violation, yes or no? And the second question is this, it's a curiosity. Did Article 33.2 of the Geneva Convention play a role in the debate? I haven't listened to the oral hearing. And the third one goes to this hypothetical argument about war. I mean, what would be the legal argument from an international law perspective? Is it because in situations of war, international humanitarian law, the jus in bello, takes over from human rights? Or is it a more generic argument and in the law of force? I mean, jus in bello, we don't have the prohibition of refoulement. Or do we? Or where else do you get this exception from? Because once you accept such an exception, it's not such a far way to say that in other security threat situations, there might also be an exception. Because also, that's maybe a final point, in July, Greece suspended its asylum legislation on Crete, and it also relied on the argument that there is a hybrid threat coming from East Libya. So the argument could be expanded. So if there is an exception, I mean, that would easily be quite right.
Thank you. And before taking the questions from home, I will also join the question from Daniel, because I was also at the hearing and I heard this question posed by this judge, but I have some difficulties in understanding what he means, because he made a distinction between negative and positive obligations, and then within positive obligation between substantive and procedural obligations. But the procedural obligation not to push back someone before assessing the individual situation is an obligation which is also effective for the purpose of complying with the substantive aspect of the positive obligation. So I don't understand how it's theoretically imaginable to derogate from the procedural without actually derogating also from the substantive obligation in the end, because especially if you know that the risk is there, like those people. And then from home, we have 2 questions in the chat. Does taking this dispute to the ICJ help resolve the broader EU-Belarus migration tension, or does it escalate them? Then, can we counter criminalization of solidarity human rights defenders as part of the instrumentalization of migration? I understand that not within this meaning of instrumentalization under the Polish Act on Protection. However, in the meaning of instrumentalization as a phenomenon, what sources would the speaker recommend for researching factual criminalization of migrants and human rights defenders? And yeah, I think we can do another. There is another question. Okay, let's take another question. Then we will do another round of responses. Okay, so let's do a round, and then if we have time, another round of questions. Thank you.
Well, thank you for the questions and also in some way reflection. Francesca, pointing out this Article 16 and whether the application, the submission might be counterproductive for Lithuania. I think yes and no. I think it might get into the spotlight with its own violations of migrant rights, but the protocol does not add anything. So those are obligations that Lithuania has anyway. So I think it's important in this wider picture that we're talking in to emphasize that the fact that people are smuggled or exploited in different ways really underscores their vulnerability, and that this is an additional reason not to limit their rights in a situation of instrumentalization. But on the other hand, the treatment that the smuggling protocol requires for migrants who are victims of smuggling does not add anything, as far as I can see, to the obligations that Lithuania has anyway. I think it allows me to add a point that I find interesting, that in some way the protocol has a different logic than human rights, but it also has a different logic than laws of war. It's about the prevention of crime. And I think I've been thinking a lot about this, President Trump and his narco-terrorists, so that he just bombs away boats of people he suspects of smuggling drugs. And I think in many places we see that the bordering between what we consider crime and what we consider war, with all the implications of laws of war, and that relates to Daniel's question about Isabella taking over, that's a very difficult line to defend nowadays when we talk about hybrid threat, etc. So in some way, I think the protocol in this case before the ICJ might provide a line of saying, yes, this is about crime, but not about war. So that is perhaps a bit of an answer to the question, does this ease tension or does this increase tension? I'm not familiar enough with what's discussed in the high political circles to really know. I think it has done neither nor. I think the tensions are there, and the ICJ submission hasn't really changed so much about this. And a quick word on Diana, I think the point was also the Geneva Convention mentioned. I find it very interesting that the states in those hearings before the European Court for Human Rights made so explicit that the threat are not the migrants. Mm-hmm. And I think what would have to distinguish is the threat. So in some way, of course, the instrument that is instrumentalized are the migrants, but is it about that they are blamed to be criminals or perhaps made actors of sabotage? Or is it about their numbers? And by saying the threat is not the migrants, in some way, I think the states have been saying the threat is their numbers, because each individual migrant is not culpable of, or not also suspect of criminal behavior. They are innocent people who are instrumentalized, but their number of arrivals, even though in total numbers that might be low, is what causes this threat. So I think that forecloses the way of saying this is a threat to national security, because it's hard to argue that those numbers as such allow to restrict those rights. But yeah, I think the states have been surprisingly clear in what path they took, because they could have argued much more. Those are people who are made criminals, or who we don't know what they have in mind, or there might be some criminals among them, and we really need to vet them. And I think this has played not such a big role in the proceedings, but Facebook is better.
Let's give the floor to Daria and then to Katin.
It's okay. I don't have that much to say. Just I would agree that I would also like to know what the outcome would be with the distinction between positive and negative obligation, because my thoughts are the same that you shared, Lorenzo, in the sense that it's not really possible to make a distinction of one without invalidating the others. And just to reply quickly on the fact that Article 33 of paragraph 2 of the Geneva Convention did not play a role in the debate.
Okay, thank you, Daria.
Thank you so much for those engaged questions. Firstly, Francesca, so actually the EU definition in this particular proceeding should be absolutely irrelevant, right? So this is kind of the starting point, that this is not for this particular case, the court, I would be extremely surprised if the court would comment on that definition at all. I'm not convinced that the term instrumentalization of migration will come up in the judgment. So there is still, I'm not very optimistic about the judgment after the hearing, I have to say. I do think for various reasons that this might go in different directions, but I'm not sure instrumentalization of migration will come up as a topic. I do agree. I don't know whether that was a question kind of or a statement, but that this EU definition does not give a lot of clarity, because in the end, it's subjectively a state deciding itself whether or not it was instrumentalized, right? It has to ascribe and so on, but there is this subjectivity. However, on the other side, the measures that the state has after it announces instrumentalization, to be honest, they're so low. It's not that the state has a lot of possibilities actually to do. So I don't think that there's a huge incentive for states to actually employ the directive in the future. And certainly none of the measures that Poland, Lithuania, or Latvia did would fit into what is allowed under the directive. So here, I don't really think it will be a response to anything. There was a political wish and need to adopt something with regard to instrumentalization, but will it be used? I would be surprised, kind of, about that. So that's that. To Daria's questions, yes, I agree with Dana and Daria that I don't see that being happening. How I understood the questions by the judge is that the differentiating would happen to people that are already on territory. So maybe you understand, but I understood that the decoupling of positive and negative rights would not only concern people outside, but it would really concern people already on territory. He was posing questions. States were not really very confidentially responding to that, but with those questions, there was a lot of explanation on what was there. So I don't know how it's going to be applied, but there was definitely a lot of thought put into that. Yeah, Geneva Convention, I also don't remember coming it up. As for the war argument, just to make clear, I'm not of an opinion that should there be a war between an instrumentalizing and a targeted state, that would automatically or at all influence the obligations of the state or the human rights protection. The argument I'm making is, in that situation, we might need to look at the particular circumstances of that instrumentalization to see whether the potential of the state, the actual threat, including humanitarian law that applies, but that also doesn't mean that human rights wouldn't apply, right? So I do think that there would be questions that would arise in that particular legal questions that are not arising if there is not a war. So I think that's more where I would pose that. And it's not that a war itself, in my opinion, would lead to that, but I do think that certain contexts in a war might lead to some questions. As to the threat, I'm not sure, but I don't think that I would need to go over my notes from the proceedings, and I don't think that the numbers were actually a topic raised. To me, how I remember the arguments, the states were more about the general situation and the general threat by Russia and Belarus, and the arguments were going kind of across that. I don't really think that they have mentioned numbers. And I don't even think that the numbers were that relevant. It was really about geopolitics and the full-scale invasion and so on. There was actually one incident mentioned that where the migrants were a threat. There was in May last year, in May 2024, there was a Polish border guard that was killed by migrants, and that was mentioned by the Polish agent, I think, in a response and not in his first comments. So kind of showing that there's also a threat. Again, this has happened long after the alleged situations in those applications, but that was the only situation where any threat by the migrants was mentioned at all. And one of the agents, I don't remember which one, actually even said that he's very sorry to the applicants that they went through this situation that was caused by Belarus. Kind of, so there was. And that he feels there was something about like he spoke to them directly, and so to me what they were trying to convene is that this is really about geopolitics and about something that is bigger than human rights and bigger than those people that came in, and this is of course. And that brings me back to your question. This is, of course, extremely dangerous because once we believe that there's something that's bigger than human rights and that the court should consider, then it's not only instrumentalization of migration, but it's also other hybrid threats, and it can be used in so many different ways. But this is actually how I understood the argument of the state, that it was really kind of saying there is something bigger than what we are talking here about, and the court needs to take that into consideration.
Thank you. I think we have time for another round of questions. So.
Thanks a lot. Thank you for your really engaging contributions. I'm happy to ask this question now and not before because this is a general one. And so I was thinking, considering the fact that hybrid threats, especially regarding migrants and especially regarding mobility policies within the EU and international legal frameworks, I'm thinking also about the new reforms in the Schengen Code, the regulation dealing with visas, a special mechanism, etc. Consider this and consider the fact that they are within the broader framework of geopolitical decisions, so EU positioning as itself versus a state or another. In your opinion, adopting a human rights protection approach, would it be better to leave these kind of cases to the judge and so have a case-by-case approach, or it will be better to have a clear definition of hybrid threats, a clear definition or a specific definition of instrumentalization of migrants as a hybrid threats, etc., or the other one? Thank you very much.
Yeah, thank you very much for your brilliant presentations. Really, I have a question. I'm interested in the issue of attracting the migrants, because Francesca, in her presentation, she mentioned episodes of instrumentalization in Turkey, in Morocco, in other areas outside the perimeter of European external borders. But I see a particular feature here in the act of like attracting, like a magnet, attracting migrants, first of all. And Grazina, you touched about this, and Dana also mentioned the issue of visas. So I'm interested on hearing your views on that. Talking about instrumentalization, that might be a kind of a pre-stage, a preparation, and the instrument is the visa here, exactly, to attract, because we are talking about, and Daria talked to us about, I mean, what are Cubans doing there, in those forests, and Syrians? And I mean, geographically, if you think about migratory flows, one would say they have nothing to do with that geographical area. So that they have been flown there through visas. So I'm interested in this kind of pre-instrumentalization preparation stage, and whether this issue of visa has played any role in the litigation before the court. How could you challenge this? I mean, what's wrong with granting a visa? Can you actually challenge that? Thanks.
Thank you. And if I may, I will use my privileges as chair to make another question, because I wanted to ask a question to Daria of whether Daria or the other lawyers included in litigation of those cases raised some issue before the court after the letter was published, because the letter specifically mentioned instrumentalization of migration, and it was a clear attempt to make pressure to the court for the decision of those cases. Now, we don't have a specific provision in the convention that says that states do not have to threat the independence of the court, but we have a provision that says the judges must be independent when they do their functions. The travaux préparatoires clearly say that they wanted an independent and impartial court, and Articles 34 and 38 talk about effective proceedings before the court, and the case law of the court on effective domestic proceedings is proceedings before judicial authorities that are independent and impartial. So from all of this, and it states said it many times, the court must be independent. So I wanted to ask whether there is a way, or you try to use a way to make the court issue a
Tesoro,
ruling.
perdono, mi stavo seguendo anche online il convegno che c'è sulla...
So whether there is a way, or you try to raise something about an attempt to affect the independence of the court in the decision of those cases. Thank you. And now we will do a round of answers.
Yes, thank you very much. A question on leave it to the judges, or as I understand, you have a bit of an overarching political, or at least overarching solution. I think such a solution would be difficult. So I think we in some way have to leave it to the judges, because even if we had a very clear definition of what hybrid threats in the context of migration mean, that would not solve the issue of what in particular cases it allows states to do. And I do think those human rights cases, but in some way also the smuggling protocol case, are about the interpretation of state obligations in that context. So I think we have to decide it in a case-by-case, on a case-by-case basis, even though clear definitions might help from harmonizing the responses as with before. And then the question about attracting migrants. So I would not call it pre-instrumentalization. I think that's very much part of it. And I agree that this is a bit particular feature of the Belarusian situation, that the opening, the active opening, or in some way one might say invitation of migration to Belarus for the instrumentalization is different from, let's say, Erdogan threatening to open the gates, or what we had before. But I think we are still talking about a situation where, well, in a world of very restricted mobility, the lifting of certain visa requirements is seen as an invitation or as an act of enabling, even though I think, let's say, we would have a different scenario yet if there were incentives, if really people were paid for coming and going to, and we're not talking about this as far as that. I've never heard about such a thing. So in some way, what Belarus does is opening mobility. And without any sympathy for Lukashenko, I don't think that as such, this is a violation of international obligations. To the contrary, in some way, it mirrors how restricted mobility, especially for people dependent on mobility, is in the world otherwise, that whenever there opens the door, this will attract like, the flow of migration. And so, yeah, I don't think, I think it plays to the core of, let's say, we said before that there are parts of the instrumentalization that as such violate rights or violate international obligations, and those that are as such fully legal. And those are the difficult ones. And I think with attracting migration, we are in this area where the actual acts of lifting visa restrictions are fully legal. And it might just be with the very bad faith intentions behind that we see them as a problem.
Thank you. Daria?
Yes, thank you, Lorenzo. In reply to your question that we discussed a bit ahead of this conference also, I guess that the fact is that this letter, of course, was clearly related to these pending Grand Chamber cases in a way. But it came at a moment in which the proceedings were already over, in a sense. You know, the Grand Chamber hearing has already been held, and all the submission, like the parties did not have further deadlines to submit submissions. So in a case as politically and legally charged as this one, I personally don't think it would have made any sense to try and raise a new complaint, especially because it is not as straightforward. It would not be a straightforward complaint to raise. It would require some, adapting of the interpretation of Article 34. So, I mean, as already been said, we started these cases with high hopes, and now we just hope that the court will just reassert the absolute nature of Article 3. So let's stick to that. Can I seize the opportunity to reply quickly to a couple of the questions in the chat that I've seen?
Yes, sure. Thank you.
No problem. So there was a question by Jakub on Frontex. I just wanted to say that, as you can see in the recording of the hearings, as regards the case against Lithuania, we did mention that actually reports of the Frontex human rights officer were used as evidence in our case. Because there was clear, I mean, we gathered some of these reports, and they clearly stated that the pushback of our applicants had taken place, and it also clearly stated that Frontex condemned this behavior and recommended, like the human rights officer of Frontex recommended that Frontex did not take part anymore in this patrolling of the borders. So there was this mention. Apart from that, I don't know in the other cases. As regards the question by Pedro on the culpable exception on NDNT, the fact is that, as we all know, so the first step of the NDNT test is see if there are effective access to means of legal entry. But the problem here is that the court, in this case, though, from what I've seen, has been pretty restrictive in the sense that it's very difficult to persuade the court that there are no effective access of means of legal entry. So I think the problem is even before then the next step, which would be then say, if there were cogent reasons to not use them. I hope it is clear. Not sure. Thank you, Lorenzo. I hear some noises, so it's a bit difficult for me to understand.
My fault. Should have put off our mic. Sorry. And last answer, and then we will read some of the other questions in the chat.
Wonderful, thank you. And thank you again for this second round of questions. So as for the case by case versus definition, I would support very much what Dana has said. And to me, when I first heard about those cases, I actually also thought those are clear-cut cases. They're super easy. There's nothing to decide about. But once they ended up at the Grand Chamber and there was this hearing, all of them together, I am certain that the court, well, I do think that the court will consider this particular context. And once the court starts considering a particular context of instrumentalization, they will be developed in the case law, some guidelines on that. So I do think that in the end, we will have something without a definition, but something that's goes hand in hand. So we will have some thresholds and some effects that would, if indeed the court, for example, decides to change their own culpable conduct and apply it in this context, I don't think the court would allow to apply that in every context where the state says there was instrumentalization, there would still be some thresholds. And the same with the positive negative obligations, I also would assume that there would be some threshold. So I do think in the end there will be a combination of both, kind of some guidelines and then case by case the decision. Yeah, fascinating question on the attracting migrants. And I do think that kind of from this intuitive citizen perspective, it makes a huge difference whether you attract. I don't think it makes any difference legally, whether it's attracted or whether they are there. So whether they're granted visas or Ireland is just saying we're opening the, legally, I don't think there is any difference. And also very often we tend to think, well, this Belarus situation is the first time that things like that have happened. That's totally not true. In the 80s, the East Germany did exactly the same, flying people from the Middle East and Southeast Asia to West Berlin, to East Berlin, and made it possible for them to cross to West Berlin. So we've seen those like giving visas and flying people in other contexts as well. And I do think there is this kind of citizen perspective that would make that complicated. I hope that the court will not consider that at all, because I don't think it's legally relevant. And Pedro, yes, I agree that it would be a broadening of ND&T or even totally changing it. But to be honest, it would be not the first one, no? So like kind of when we change this interpretation. So I do think that there is, well, with this exception, some road was opened that now the court can also take in other solutions.
Thank you so much. And I think we are running out of time, but we still have time for reading some of the comments. So we have Thomas Molnar from the Fundamental Rights Agency of the European Union that says, as per the litigation before the ICJ, Lithuania versus Belarus, the Commission will participate on behalf of the EU in the, there is someone with the mic open, in the proceedings in the case on the basis of Article 43, paragraph 2 of the Rules of Court by filing a memorial in the registry before the closure of the written proceedings. The Commission will therefore soon inform, or maybe has already done so, the ICJ registrar that the EU intends to submit observations pursuant to Article 43, paragraph 2 of the Rules of Court. And then we have another question. Is Frontex involved or excluded from the situation on the Polish and Lithuanian borders with Belarus? In your research, did you find any information about the role or possible role of Frontex? I don't know whether probably this is more a question for this afternoon, because we will mostly deal with European Union law and also the role of Frontex. And just last comment, very long actually. I really thank the organizer and panelists for the truly interesting and brilliant intervention. Many reception and social assistance systems are on their knees in those EU countries where the emergency has been and is becoming unsustainable in terms of also ensuring the protection of migrants, especially those who are victims of human trafficking, who are still unable to be promptly identified. In the difficult balancing of fundamental human rights, use cogents, and the protection even of the capacity to manage and guarantee assistance by states. I didn't get the reception. in the difficult balance, I didn't get the answer. Final sentence. Okay. States have always and only been condemned by the European Court of Human Rights, but this is now, even after years of Rule 39, has not led to a result of increasing and guaranteeing resources and effective protection by not collapsing into their own internal systems. Just for example, today, Italy is also struggling, especially on the Balkan route, which is largely kept quiet to guarantee access and protection to forced migrants. I believe the EU state are faced with a new rule of law paradigm in these areas, ensuring protection, but also protecting their own democratic system, as has been observed. I would like to know from the rapporteurs, from those who wish to respond, what opinion they have on the instruments of the new European Pact with respect to the difficult balancing, human rights protection, rule of law. Will it be possible to find a way of checks and balances in the application of the pact? I think in any case, we will deal with the question in the afternoon. So thank you so much for this incredible panel. Thank you to our incredible speakers, and thank you to Daria who was with us online, and I hope to see you soon. Thank you, and let's go to lunch.
Thank you. Bye.
Practical directions, we will gather here again, maybe just a little bit ahead of time, because our afternoon session starts at 2:30. Let's keep it relaxed. We may want to begin a little bit in advance, maybe 2:15, 2:15. We'll be back here. So for those who are remotely connected with us, let's resume our works in the afternoon, and thanks for this credible participation, even by you all connected online. Thank you again.
Yeah, we were.
Should I type in that we're starting 2:15?
Yeah, probably. Okay. Sure. And then I have to see what my student was. Thanks. That's really